We will go on the record in the matter 24 CF 176, 24 TR 741 and 742. State of Wisconsin versus Rebecca Allmendinger. The state appears through Assistant District Attorney Jose Vila in person. Ms. Allmendinger appears in person with her counsel, Bruce Anderson. We're set today in this matter for a plea and sentencing. I have confirmation that Ms. Allmendinger has completed our IDIP program and has sat 48 consecutive hours. Is that accurate, Mr. Anderson?
It is.
All right. So we've reached an agreement. Can you please recite the agreement for the record?
Ms. Allmendinger will enter a plea of either guilty or no contest at the court's discretion to count one of the criminal complaint against her in 24 CF 176, which will be the operating motor vehicle while intoxicated fourth offense. The other counts will be read in and dismissed, as well as the 2 traffic citations. As she completed the IDIP program, I anticipate the court sentencing her in accordance with the guidelines. There is $1,500 of bond already posted. She has her money for Ms. Anderson for at least the first 30 days of the monitoring program. I believe that's the status.
All right. BAC 0.256.
It was. We are abandoning any challenges to admissibility of that evidence at this point.
All right. Did you discuss the additional community service at 225 hours?
Was that discussed with you?
And what you wanted to do with it? At the last hearing, I went over whether or not you wanted to complete that and do that as community service, or you do have the option to convert that to additional jail days at your expense. For one day, it's 8 hours of community service that would be knocked off. Therefore, it would be 29 additional days.
I guess I would like to do the community service.
All right, and that must be completed before the end of your sentence.
Okay.
Okay,
How many hours?
225.
So.
That would be 29 days.
Oh,
Well, 28 if you actually work and do that. It's 28.1. However, the court rounds up.
Okay, so like basically
29 more days.
29 8-hour days of community service would need to
Correct.
be completed.
Before the end of your sentence.
Or you could take roughly 30 days of additional.
Or it would add 30 days. So essentially what that would mean is if the court grants you the ability to serve jail sentence as in house arrest with certain abilities to go elsewhere, that would add 30 days or 29 days. However, you would, what you would need to do is just that 30 days house arrest additionally, and then the additional 25 days per day for a monitor. So I don't know. So 29 times 25, that would be an additional $725.
8 hours a day. 30 days. You're more than that, don't you?
I think that I should probably just do the extra 30 days because I don't, with my license being revoked and stuff, I don't know how I would be getting.
And I am totally fine with that. Just for the record, it's an additional 29 days. I know
Okay.
that give or take, it doesn't really matter to you probably, but I do have to do it precisely. And that's fine with me. Quite honestly, either way, the county is getting a benefit from that because you have additional confinement days, plus that additional money that you would be paying for the monitor does go back into the county for resources like the ability to continue to offer monitor to others. So, okay. All right. Do I have a plea questionnaire waiver of rights form?
Yes, and I'm having her sign the addendum right now. I forgot that first.
That's okay. Thank you. I do have in front of me the plea questionnaire waiver of rights form. Do you recognize this document?
Yes,
Is that the document in front of you?
yes,
And so you are pleading guilty to OWI4. You're 43 years old. You have 12 years of schooling. You can read, write, you understand the English language. Is that correct?
yes,
You do suffer from bouts of depression, but do you take medications for that?
yes,
And so did you take them as prescribed?
yes.
And with that and or your medications, do they put you in any type of condition where you may not be able to understand or comprehend what's going on?
No.
So today you fully understand and comprehend.
Yes,
Okay. Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
yes,
Okay. And so did he also go over the mandatory minimums as well as the potential maximums that you face?
yes,
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of that plea questionnaire. Did your attorney thoroughly go over those rights with you?
yes,
Do you understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Did you sign both of the documents, the plea questionnaire waiver of rights form, as well as the addendum?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
yes,
You'll no longer be able to vote in any other election until your civil rights are restored.
yes,
Do you understand you're pleading guilty to an OWI4? That means your privilege to operate a motor vehicle will be a lifetime revocation.
yes,
Do you understand that here the state would have to prove on or around July 20th, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while on a highway or roadway of this county and state, well, under the influence of an intoxicant.
yes,
And so you understand what they would have to prove?
yes,
You understand the minimum potential possibility could be, you could be fined not less than $600 or imprisoned for not less than 60 days. But there could be a maximum possible penalty of up to $10,000 or imprisonment of up to 6 years of incarceration or both.
yes,
You further understand that you did complete the IDIP program, which would have certain privileges, such as a lesser sentence, as well as the ability to argue to the court to have any house arrest and be on monitor.
yes,
You understand, I'm not bound to follow any of that, even though you completed the program. You understand? So I could sentence you all the way up to that maximum possible penalty if I thought it was warranted. Do you understand that?
yes,
Do you still wish to proceed and enter guilty pleas?
yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, there's that section called the probable cause section where it basically says what happened that day and why you were charged with crimes.
yes,
For the most part, are those facts accurate?
yes,
Are you pleading guilty to an OWI4 conviction because you are guilty of that charge?
yes,
Mr. Anderson, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge, I'll stipulate to that.
Has anyone made any threats or promises to you for you to plead guilty to this charge?
no,
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Has he discussed with you all of the evidence and the discovery that he has received?
yes,
Has he talked to you about a potential for any legal defenses or a lack of defenses? Like if this were to go to trial, did he say, well, we could argue this and this could come into play, or sorry, I don't find that you have any defenses?
Yes,
Are you satisfied with his services?
yes,
Any questions for the court or for your attorney before I proceed?
no ma'am.
Then as to count 1, OWI4 in 24 CF 176 and H felony, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and merged in with count 1. The other TR matters will also be dismissed and read in. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation for this case is appropriate. Ms. Allmendinger is here taking responsibility for her actions. She has since completed the IDAP program and has received access to resources and programming, which will hopefully ensure that she does not reappear in front of the court in this manner. I think the sentence also accomplishes the goals of specific and general deterrence, specifically deterring Ms. Allmendinger that if she continues to drive under the influence, she will continue to face harsher penalties as she has crossed over to the felony level offenses for OWIs in Wisconsin. As for general deterrence, I think this sentence accomplishes the goal by letting the public know that driving under the influence will be taken seriously and that some of these offenses can carry harsh penalties. I also believe that the need to protect the public here will be accomplished since her driving privileges will be revoked. As such, I would ask the court to adopt the joint recommendation. Thank you.
Thank you. Mr. Anderson.
I think Mr. Villa has actually correctly set forth the joint recommendation as well as the IDIP purpose as well as the guidelines. I'm thinking that Becky has now realized the seriousness of this. She now has a felony record with nothing else on her life history other than alcohol-related offenses, and it's landed here now. She's still got work ahead of her to make sure she complies with the monitor program and does whatever is required of her through that program. So with that said, I believe I have to echo the joint recommendation. I can't say enough about how Becky has, frankly, from the day I started representation of her, she has been highly communicative in response to me reaching out to her. She has been highly communicative from her end, checking to make sure if anything is scheduled or if anything else that she needs to do as we proceeded through this matter. So I think she's a responsible person, and she's 43 years old with nothing besides these drinking issues on her record. So the court to take all that into consideration in coming down with the sentencing. Thank you.
All right, thank you. Ms. Allmendinger, do you care to make any statement, tell me anything about this or about you or what you've learned? You don't have to, though.
Well, yeah, it's a pretty big wake-up call, the consequences, not only to myself, but to the people that care about me and that I care about, my children, my family, everything. And it is not taken lightly. I am sorry for my shortcomings, and I am taking seriously addressing my problems with alcohol. You know, taking a lot of different steps to find other ways to deal with the things I used to use alcohol to deal with. So it's a terrible situation, but I have trying to focus on the positive of it, that that I'm learning and growing because of it.
I appreciate that, Miss Almendinger. This is a more serious charge. People, I'm going to tell you, I have people that have come in front of me for OWI thirds, and I tell them, I try and say, hey, do you understand how serious it is if you get an OWI fourth, because it's going from a misdemeanor to a class H felony, and then you lose your privilege to operate a motor vehicle for life. I'm going to tell you, not a lot of people heed my advice or heed my statements that I make, and it's unfortunate because it is such a drastic change in the sentence from the misdemeanor OWI third to the H felony OWI fourth and the mandatory lifetime revocation of driver's license. I'm going to be honest, Ms. Almendinger, I like you. I like you. I liked hearing your testimony for the collateral attack hearing that we've had. I believe that you are an intelligent woman, that I got a good feeling from you in hearing more about you while you were on the stand. And I get a positive feeling from you while you're sitting there. You seem like a nice person. You seem like a genuine person. A person who unfortunately suffers from a substance abuse disorder, that you self-medicate with alcohol. So instead of reaching out and doing a fun activity or calling out to a friend and going horseback riding or making a craft or doing something like that, going for a walk, instead you reach for the bottle of wine or beer or whatever your choice is. It really is unfortunate because this is such a severe sentence, and it does impact not only you, your children, your significant other family and friends, because now for the rest of your life, you have to rely upon others to bring you places or to go places or to visit. It's a serious, serious implication, and it's a serious ramification for somebody's conduct. And I wish for you that you would have understood that and reflected harder upon these consequences prior to getting into the vehicle on July 20th, 2024. As a judge, it's my job to sentence an individual and sentence in accordance to at least the parameters that I am mandated to sentence. And here it's the OWI4th. I have no choice but to revoke your driver's license for life. And OWI5th, Ms. Almendinger, please heed my advice. I'm not going to say that you're not going to be one that is going to, you're not going to abide by the, you may not drive ever again right now. I'm not going to say you're going to drive. I'm not going to say you're not going to drive, but I'm going to tell you, please heed my advice. Heed my advice right now. An OWI5 mandatory prison. It's mandatory prison, a year and a half in prison, not jail, not the ability to have a monitor and be under house arrest, prison. Please think extremely careful. Think twice, think 3 times, think 4 times before you get behind a wheel if you've been drinking. And I know you're not going to drink because, or you're not going to drive because I'm revoking your driver's license. But I'm going to tell you, I see multiple people who do it anyway, and it's an operating after revocation. Please don't do that. Please don't drive. But please think harder before you get behind any wheel if you've had any intoxicants, okay? Because that's going to be a harder time for you and your family. So you've completed the IDIP program, you've done what you needed to do, and hopefully you've learned a lot of things. Hopefully you've learned that you can't use alcohol as a crutch. It will only destroy you. Hopefully you've learned that you are a good person, you deserve to have a good life, and that if you are suffering, that there are other alternatives and you can reach out, or other things that you can do. This is serious. The legislature tells me it's serious. Everybody knows it's serious. Thank God you weren't injured. Thank God someone else wasn't injured or killed. I have to protect the public, and here Mr. Vila said it clearly. The public is protected because you will no longer be able to use or drive. Use a driver's license, drive again, or do anything like that. So with that, the court is going to follow the recommendations as it relates to the IDIP program. I'm going to admit that when I gave you the information about the community service and the fines and whatnot, I looked a step higher in the 0.2 to 0.249 range. So I'm going to abide by that because that's what I told you. I'm not going to do the harsher one of 0.25 or above. So I'm going to sentence you and fine you $2,543 in fines and fees, plus a $10 blood draw. 165 days in custody, but for the 225 hours of community service converted over, plus you had 2 additional jails, 2 days, and with 16 additional hours of community service. So I will sentence you to 192 days of jail. You won't need to get your OWI assessment or follow through. I don't know if the legislature still requires me to order that, but you are revoked for life for your driver's license.
What did you say about the assessment?
With every OWI, I'm supposed to order an OWI assessment and follow through. You should have done that with the IDIP program. So I will order the OWI assessment and follow through. Usually that's just so you can get your driver's license back, but you did the IDIP program, so that's great. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. You're going to owe a little over $1,000 more in fines and fees. I know it's going to be hard because you're not going to be able to drive to get to work, but with that, I'm going to order at minimum $75 a month to be paid. I'll give you a little bit of time to be able to cover the electronic monitor because I'm going to guess that Mr. Anderson is going to argue for that. So I will say June will be your first payment for fines and fees. So you pay the clerk up here. If you can pay it off sooner, do so, because if you miss a payment or you don't pay this back, not only will I enter a civil judgment against you because you're always going to owe it, I will issue a warrant and you could sit up to 6 months in jail, okay? Because that's a part of the sentence as well. And with me giving you the incorrect information in the beginning, you're already getting a significant benefit.
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. So what you're going to do is when you're done here, you're going to exit the building, go all the way around to the back of the building to day reporting for the jail. You're going to provide your DNA. In a case like this, with this felony, I'm not sure, but you may be able to have it expunged through the system, through a written letter to the Department of Justice, not to this court, to the Department of Justice. Even if you gave your DNA before, I still have to order it. I think that's everything, Mr. Vila.
I believe so, Your Honor.
Mr. Anderson?
Judge, actually, she's entitled to 3 days credit. She did the parts of 3 days and that exceeded the 48 hours by
Yes.
about 7.
Plus 3 days of jail credit. All right. I'm gonna, what you're asking for the monitor, correct?
Yes.
And she doesn't have any convictions that would be questionable or cause like dishonesty, et cetera.
No.
All right. Are you opposed?
No objection, Your Honor.
So I will grant you the ability to serve your jail time by monitor. You must be hooked up today. And you have to pay at least 30 days in advance. All right. You'll go probably meet Dave Hatch and he'll get that all set up. I am going to tell you that if there is any violation on the monitor, you will be told that you're immediately revoked and you must go report to the jail to serve the rest of your sentence. No good time, no Huber if you're revoked. Okay. When you're on the monitor, it's house arrest. You may go to work. You may go to do community service if you have other things that you want to do or just engage like that. You may go to the doctor. You may go to church. You may go to the grocery store one time a week, but you may not go to anything else unless I specifically approve it. If there's a funeral, someone close in the family dies, you cannot go unless I approve it. Do you understand?
Yes.
With the new monitors, I'm not exactly sure how sensitive they are. They are 24-hour, 7-day a week GPS monitor and alcohol monitor. All right. So I don't know if these are as sensitive as our last monitors, but I'm going to tell you, if you don't be around anything like gasoline near it or rubbing alcohol or something like that, because if that goes off and it sets that there is alcohol, I accidentally dropped a bottle of alcohol on the thing and it set it off. I wasn't drinking. I don't take excuses. You will be told to immediately report to jail and serve the rest of your time. Again, no good time or Hubert. Do you understand?
I do construction, but like when you say gasoline, you mean just not get it on it?
And this is the moment the consequences really hit home. An OWI4 offense isn't just another DUI case. The court is treating it as a Class H felony with a mandatory lifetime revocation of driving privileges. The judge is clearly trying to make one point stick. This isn't only about punishment for what happened in 2024. It's about preventing the next decision from becoming something far worse. Do you think a lifetime driving revocation is an appropriate consequence for a fourth OWI? Or should there be a path to earn driving privileges back?